Intellectual properties or IP. You might wonder what are these IP or intellectual properties are. Also, as researchers, you always want to have some properties from your research work. But nowadays we might only focusing to publish our work or go to a conference and present our work, maybe a poster, or let's say writing a book chapter. But remember, all this research work you do can create properties. So you might wonder what are these properties. So today we're going to discuss about basics of intellectual property rights. This video is mainly focusing undergraduate and graduate students, but anyone can learn many things from this video. We must answer the basic question first. What are intellectual properties? In our day-to-day life, we have seen many properties: lands, buildings, cars, jewelries. All these comes under the usual property category. So all these properties having some kind of documents to prove the ownership. For car, there's a book, and for lands, deeds, even for these jewelries and other things, you might have a receipt or a warranty card. These are the documents that can be used to prove the ownership. However, intellectual properties are different from these what I mentioned earlier. Some intellectual properties you might not be able to see from your eyes. The ownership, there might not be a document to prove. But there are some other properties comes under intellectual property category. You can touch, you can feel, you can see from your eyes. So how you categorize these into one group? What is the key feature you can use to identify intellectual property, so IP? The basic property of all intellectual properties are these properties created using our mind or our knowledge and our mind together. These properties are created. So you might wonder, can our mind create properties? Yes, sure, we can use our mind to create properties. That's why I said in your research work you might think to publish the knowledge you created, or you might only think to do a presentation at a conference. But all these knowledge you created using your mind comes under intellectual properties. To broaden this discussion, the knowledge you created comes under intellectual properties, or any creation you did using your skills comes under intellectual properties. For example, if you write a book, if you write a song, these comes under intellectual properties. Even a drawing, a photograph, all these comes under intellectual properties. I hope you now understand what are intellectual properties and how you identify an intellectual property. So your research work, have you ever thought about intellectual properties? Or do you have some idea whether your research work going to create any IP rights? So at the end of this small discussion, you will understand what type of intellectual properties a research can create and how you protect or how you own these intellectual properties, how to use these intellectual properties to create wealth or money. I hope this will help to improve the efficiency of your research and to protect the knowledge you create from your research work. Just a while ago, we looked at some examples for intellectual properties. A song or any knowledge you created in your research, a movie, these are intellectual properties. But we should look at or discuss more about this category. There is a new category and we identify a key feature. Using our knowledge, we can create intellectual properties, or using a set of skills we have, we can create intellectual properties. The main intellectual property relevant to your research work is innovations. An innovation that create using your knowledge comes under intellectual property category. Let's say in your research you find new compound. For sure, it's something new. It's an innovation, or new device, new process, or if you find some kind of a property of a new material, if you really produce a material that have zero resistance. So all these comes under innovations. The knowledge you have created these innovations, so they can call intellectual properties. But there are some other IPs not really created using your knowledge. For example, songs, movies, software. These are created using some set of skills plus your experience, and sometimes you are using your knowledge. For example, a song, you are using one of your experience and you are skillful writing songs. Then these two combine together to create a song, a movie or a video. Let's say somebody creating a small short movie. Then your skills and your experience, all these things can be come together to create this segment. Now, in addition to these two categories, there are a few others. Some companies, they have some secrets. They are not revealing their secret. So whoever working in the company definitely know this secret, but they cannot tell this secret to another company. These are coming as a secret of that institute. It can be a secret, a way to do things, or a formula that they are using to produce some kind of a product. However, these are again intellectual properties. In addition to these, I explain brand names. If you go to a supermarket, you will see many types of products with different names. So how you find which is good? Maybe based on your skill or based on your knowledge, you read it, or by looking at it, you select what you need. So this brand name, again, a intellectual property. Now, remember, a brand name definitely not knowledge. It's some kind of a skill person developed, maybe a design. It can be protected under intellectual property law. So no other company can copy that. Not only brand name, there can be slogans, there can be many other things comes under a brand name. So these are some of the examples. Now remember, we have to understand the Sri Lankan law for intellectual properties, and the international law based on each country might be a little different from Sri Lankan law. It's not really necessary to understand all these things, but as an undergraduate or a postgraduate student, you should have some basic knowledge on intellectual properties, because you are creating new knowledge. You can protect this knowledge to use to create wealth for your usage or for the university, and it can be both. So it's important to understand what are intellectual properties. There are many categories of intellectual properties. If you Google, you will find 5 categories, 6 categories, or 7 category classification for the intellectual properties. But I want to go for this 4 category classification to make our discussion simple. So if you remember, earlier we discussed innovations. You develop a new material or a process to synthesize a compound or to separate a certain product from an industrial process. Now these comes under innovations. If you have an innovation, the best way to protect it using a patent. Patent is a document issued by the government. Some people say there is a patent to cover the whole world. No, there's nothing called universal patent. Patent only cover a given territory or a country. So the other 3 categories are, if you have a song or a movie, some kind of a drawing, a picture, a photograph, all these comes under copyrights. That prevents anyone else using it, distributing or editing, and proves if you have copyrights for a certain idea, using copyright law of Sri Lanka can protect it and keep it under your ownership. Trade secrets can be used to protect information. Even though I say just information, this information should be with a certain commercial value. If you have any information without commercial value, you cannot or not qualify as a trade secret. Many companies keeping their information under this IP category. The last one, under these 4 category classification, trademarks. Again, trademark can be a diagram or a slogan or combination of both to identify a product or a service. Product means if you go to a supermarket, you might see various type of soft drinks, various type of shampoo, various type of pens, various type of food packets with different names. If you see a name on a packet of a product, that's a trademark. Sometimes a diagram plus letters or a sentence, so that's called slogan. So it's a combination of both or just one. Not only product have trademarks, even services. Your mobile phone, it's a product, but the service provider, the telecommunication company, it's a service provider. They have their own trademark. So if you think about the Sri Lankan telecommunication service providers, they always have a trademark and a slogan. So there are really nice slogans they developed throughout the time. So the slogan or the trademark having some kind of a value. So that value is the star power of that product. Allows customer to identify or differentiate it from other services or from other products. So this is the 4 category classification for IP rights. If you Google, like I said at the beginning, you might be able to find various other classifications, might extend or add some other components, but this is enough for our discussion to understand what are IP rights. Under this 4 category classification, the first one we're going to consider is patents. A patent can be applied for an innovation, but there are tiny other things you really need to understand whether your innovation qualified for a patent. Remember, patent is issued by a government or a territory. For example, European Union, you might be able to cover certain regions. But in Sri Lanka, if you need to have a patent, you should apply to NIPO, National Intellectual Property Office. If you Google NIPO or NIPO, you will be able to find the website and more information about the Sri Lankan law for the IP rights. If you get a patent to a certain country, always you have rights only within that territory or within that country. Somebody from another country can easily use it or take your idea, can execute without any legal barrier. That's why many companies, many inventors really try to cover the major markets or major production regions when they apply patents. However, at the end, you need to apply or cover more than one country. To qualify to obtain a patent, your innovation should be new. So that's the first criteria. New means it should not be reported before, not as a video, not as any picture or on a web page, news, books, journal articles, or any other means. Even a discussion in a public forum can consider as reported previously. But the question you might have now, reported previously means by others or by the inventor. It doesn't matter. Even if you report your innovation priorly, applying for a patent can consider as reported previously. But there are certain issues on this, or someone can say certain concessions on this law. However, the advice is you must apply your patent before you publish. If you apply the patent today, tomorrow you can submit your journal article to a journal no issue because you have applied the patent before you submitting the journal article. This is something you must remember if you need a patent. First criteria is novelty or new. The second criteria is innovative step. So what is innovative step? Innovative step is someone with the knowledge or sufficient knowledge on the in that field should be able to really develop it based on the obviousness. Now, to clarify this little bit more, if you have a chemical compound with antioxidant property and you have another chemical compound with antiviral property, antioxidant and antiviral property. So if you combine these two compounds, the final mix or final mix product should have antiviral and antioxidant properties. So it's obvious for a person with the knowledge in that field. Then it cannot be an invention because it's obvious for many of us. However, let's say by combining this antioxidant and antiviral compound together, if you can prove this new mix have some new property, for example, it might have anti-cancer property, then you have an innovation. But remember, it should not be reported previously. Novelty should be there, innovative step should be there. The last one is there should be a utility. Utility means you must have some kind of a usage of your invention. Otherwise, there's no way your invention going to qualify to obtain a patent. So these three criteria should be at least satisfied to obtain a patent. There are other some criteria, but these are the three main criteria you must look at if you really want to obtain a patent. A patent only valid for 20 years from the day you apply. That's the basic rule. But technically the correct term is not the day you apply, from the priority date. The office will assign a day where this 20 years start count. From that day, you have 20 years to do whatever you want with the patent. But one misunderstand. Most of us may have patent never gives you any rights. Patent actually put some restriction on others, or patent prohibits others using your technology. So it's a complex discussion, but simply you can understand patent really allows you to use the technology. Patent allows you to give it to anybody you want. Patent allows to produce whatever the invention you disclose, sell it, export, import. All these rights will be given. But remember, if someone else having someone little similar to your one, then that person's patent right you might violating or infringing. So that's why I said patent never assure you to do anything you want, but patent can really prohibit others using your invention. As an undergraduate student or a postgraduate student, let's say you want to get a patent. All the universities having TTOs, Technology Transfer Office. So I am working the Technology Transfer Office at Faculty of Science as well as University of Colombo. However, I'm a lecturer at Department of Chemistry, University of Colombo. In addition to my academic work, I'm working at this TTO office, Faculty of Science, and TTO office, University of Colombo. Now, if you have something you think it's novel, there's an innovative step and a utility is there, then you can talk to the TTO office. The first thing they'll ask to submit IDF. So what is IDF? Information Disclosure Form. So based on this information disclosure form, you describe some basic features of your invention. Then the TTO office will look at it and run a quick prior art search. Another new term. Prior art means any technology reported previously. It can be a journal article, it can be a patent, it can be a diagram, a video, a book chapter, a paper article. Anything comes under prior art. They look at whether the invention you described in IDF reported previously or not. If not, they're happy with the first step, then they'll ask more information. With the more information, the TTO or Technology Transfer Office conduct a patentability search. They look at all these criteria we discussed earlier: innovative step and the utility, other tiny beanie information they look at. If they are happy, then we can go for the next step, the drafting. So drafting is a different process compared to a journal article. In a patent document, you might see the abstract or the introduction, information, but those are just formalities. The most important part is claims, what you protect. So claims clearly define what belongs to you or what rights protected by this patent document. So easily you can go to Google Scholar and find journal articles. Similarly, if you go to Google Patents, you can search patent documents. One thing you need to remember, many countries publishing their patents in their native language. Chinese patents in Cantonese or Mandarin. Chinese publish it in their own language. Korean language. Japanese. So that issue is there, but still Google Patent do a automatic translation. You should be able to read it in English. Look at Google Patents and do a quick search and see whether you can find something similar to your research work. So the new words you learn: IDF, prior art, patentability, TTO, there's another word, TLO, Technology Licensing Office. After getting a patent, what you should do? Or after applying a patent, what you should do? If it's really a valuable invention, you should not stop just with a patent. You must go for a commercialization. Give it to an industry and give your innovation to the consumers through a commercial partner. That will create wealth. That wealth can be transferred to university and for the inventors. This really is the process you must remember if you want to apply for a patent. If you ever talk to the TTU office at your university or the institute, they will explain to you there are two pathways to protect your innovation. The first or the most simple pathway is directly file to cover the country or the territory you like. For example, you just file a patent application to NIPO to cover Sri Lanka. From the day you submitted this application, you have only 1 year to submit application in any other country. Now, for example, if you submit the application January 1st, 2021, you must submit all the application before January 1st, 2022. So today is January 1st. You submitted the application. So we can consider today as the submission date. If your patent is accepted, then from today you have 20 years to use these rights and do whatever you want. But you have only 1 year to submit application in other countries. So how about you apply August or in November another patent application you submitted to Indian office. So the 20 years start counting from November? No. Since you have submitted an application in January 1st, 2021, the Indian office will ask, or you have to inform them, then they will put the effective date from the first submission date in Sri Lanka. So that's called priority date. So the day you submitted the first application, consider as the submission date, but it also consider or can be considered as the priority date. So whatever application you submit within the first year will consider the first submission date as the priority date. From that day you have 20 years. But this 1 year is really difficult to utilize in an effective manner because it's only 12 months. And the expense you have to really file application in various countries is huge. And the commercial partner might need little time to decide which territories they might have better opportunities to create more wealth. So that's why the WIPO, World Intellectual Property Office, have a different route. You can submit a PCT. So it's not a patent, but it's a document you submit to the WIPO. Then from the day you submitted this PCT document, you have 30 months. They will provide a search report. The search report tells whether it's having this novelty or whether it's having this innovative step and all this information. From the day you submit your PCT document, you have 30 months to file the national application to get patents in each country. Remember, 30 months. Now compared to earlier path, now you have more time to decide which countries you would like to go. There are other advantages in PCT method, but it's not the time to discuss all these things. Your TT office will explain this more to you, or you can go to WIPO website. They are providing some wonderful free courses. You can follow those courses and get knowledge on IP rights and patenting and other things free of charge with a really valuable certificate. So try the WIPO website. Under distance learning, you will find these courses. We have discussed what are patents and how to get a patent and some basic rules about obtaining patent. Let's go to the next category, copyrights. Now, copyrights covers any expression. Even my video you are watching now, it's an expression made by me. So it's under copyrights. You can see the symbol I indicating there. I have certain rights about my expression. So the basic rights, according to Sri Lankan law, no one else can copy it, distribute, edit, or modify, earn money using this. So all these processes are prohibited under Sri Lankan law. So the question you might ask, do I have to really indicate this letter C with a circle and all these things to obtain the copyright? Not really. Whenever I express an idea in a public forum, in my Facebook, on LinkedIn, TV, anything, it automatically comes under the copyrights, or I have this privilege according to the Sri Lankan intellectual property law. One thing you have to remember is some other countries you can register the copyright. India, US, they have a registration system. So this video can be sent to this one of this office and register as a copyright. So then I have a proof. If someone say no, I did this first, I can show this registration at the copyright office and prove to the court or to them, see, I did this on this day, so it's my property. A mistake most of us do is, if you really create anything as an employee, as a university employee or an employee of any institution, or as a student, anything you create belongs to the institution. Even innovations and everything belong to them. You can be the inventor, but the ownership of your innovation or patent ownership, all these things belongs to the institution based on their IP policy. So check the IP policy of your institution before you proceed. But usually if you are a paid employee, then it belongs to the institution. So that's why in some cases people misunderstand when we hire someone to take some photographs or assignment basis, we might think it's again belong to them. The reason why, because you paid for the original creator. But that's a mistake. Always it's advised to have a copyright transfer agreement. If you have hired a person to take some photographs for the book cover you are going to do next month, your first book, then it's good to have a copyright transfer agreement from the original creator. So that's the usual mechanism. You can Google and see and find many copyright transfer agreements. Any such creation done by outsider for your work, it's good to have a copyright transfer agreement. Copyrights really covers any expression of idea: movies, songs, essays, drawings, diagrams, photographs, anything. That means if you distributing a movie or a MP3 songs of someone else, it's really you are violating their copyrights. But under the education usage, the teachers can use some of these educational contents, some up to some extent, for the educational purposes and non-commercial purposes. Every picture on this slide definitely familiar to you. Now these are trademarks. Previously we discussed about copyrights. So copyright is an expression. So why not a trademark cannot be an expression? It depends on the usage. A trademark really valid forever as long as you pay 5-year fee. You can keep the trademark forever. So any trademark can go forever as long as you pay the money. But a copyright only valid for a certain period of time. So how long a copyright valid? A difficult question, because it's not really known to us. You might ask why. Think about this video. How long the copyrights of this video valid? Then you have to think, when I'm gonna die, because I'm the content creator. 70 years from my death, the copyright can be retained. Not to me, because I'm already died, so I can transfer this copyright to somebody else from my death, 70 years for expressions or pictures, in this case for this video. But trademarks, it can go forever as long as you pay the money. Now trademarks, you only see pictures here, but remember I told earlier, trademark can be even a slogan, set of words or set of letters combined together, or the combination of both. Trademark can go forever. That's the advantage for a commercial entity to use the same trademark again and again for as long as they want. And the other important thing is, trademark can have various colors. You can't say just red and blue and indigo. You need to use an accepted coding system like hex or other color coding system to express each color when you file the trademark. A trademark is a unique property for an entity that gives the identity for a product or for a service done by that entity. So trademark can be a valuable asset for a company. Some companies, they even sell some of their intellectual properties to others, but they never ever sell their trademark, because trademark, every year the value will go up, because more people accept your product, the value of the trademark go up day by day. The fourth category we're going to discuss is the trade secrets. So now the question is, how you really protect trade secrets? Now many institutes, many commercial entities, their employment agreement really comes all these things. You can't disclose these and that and this. That's how they protect their trade secret. So why people keep it as a trade secret? Why not a patent? Now, for example, Coca-Cola formula is actually a trade secret. They somehow kept it as a secret for many 100 years, and they probably keep it for the coming years. What is the disadvantage? If they patent it, then they have only 20 years. That's a disadvantage. The advantage is they can keep it forever if they can maintain the secrecy of their formula. The disadvantage of trade secret is, if I can independently develop the Coca-Cola formula, I can produce Coca-Cola and they cannot do anything legally against me, because I independently developed this formula, which is kept as secret by the Coca-Cola mother company. But if they file a patent, even I do it independently, they can take legal action against me if their formula protected in Sri Lanka. If not, I'm free to produce it here and sell within Sri Lanka, but not to export to any other country which is protected any of their inventions. So trade secret, there are advantages and disadvantages, because reverse engineering, can anyone develop these secrets or produce same process? If so, then they cannot do anything legally against that person or that against that industry. But a patent always gives the full protection. But the disadvantage of a patent is you have only 20 years to do whatever you want. If you have a copyright and a patent, again, two things you have to understand. Patent we always call inventorship or the inventor. Even though the university is the owner of your patent, they will list you as an inventor. In a copyright document or a expression of idea, then you have the authorship. In inventorship or the authorship, there can be joint authors or joint inventors, but the proportions never ever define on the patent document or the copyright registration. So if you want to define I have 60% or 40%, then you have to have a separate agreement among the inventors or among the authors of whatever the expression. So these need to be discussed separately, how and why need these agreements. But one agreement, you always keep that in your mind, NDF, non-disclosure form. Whenever you go and discuss with a commercial partner about your invention, first sign the non-disclosure agreement if you are not really filed a patent document, or file a patent document and sign a non-disclosure agreement. So both these are better, but at least one there should be before you discuss your invention with a commercial partner or with anybody outside your research group, because your invention, if it's disclosed or if it's go out, you will lose the patentability. It's really important to understand your research before you start it. Whether your research is going to produce any IP rights, or can you produce IP rights through your research project. Many of you perform a really good literature search, but you might forget to perform a proper prior art. So you can visit the TTO office of your university and talk to them and learn how to perform a proper prior art. That really avoid you are redoing what others already done. At the same time, you can ask when you can come to their office to protect your invention, or if you want to protect your invention and commercialize, you can really get help from them. But if you want to learn a little bit more about IP rights and commercialization, please visit WIPO webpage. They have some courses. They are free of charge, but again there are paid one also. The basic ones are free of charge. And NIPO webpage have some information under each category of these IP rights. Remember one thing: if you don't protect your invention, that's your decision, but if you protect it, always try to commercialize it. Otherwise the time and the money spent on IP protection is wasted. It's essential to have a plan before you think to protect your IP right. Just filing a patent, it's not worth, because it really wastes some resources. But if you file a patent, always finish it as a commercial product, or transfer this knowledge to a commercial partner to commercialize and earn some money as inventor plus as the university.